I'll have each of the speakers give you a little brief introduction about themselves as they get going. As Tom mentioned, I'm a partner at Steptoe & Johnson. Before joining Steptoe, I was the Deputy Assistant AG in charge of computer crime at DOJ. So in that capacity, supervised criminal investigations of some of the bigger data breaches, and now that I am in private practice trying to help companies deal with the risk and the aftermath. We're very privileged to have the assistant AGs for Vermont, Florida, and Pennsylvania here who have primary responsibility for data breach investigations, and it's a real privilege for us to be able to spend an hour with them getting inside their heads and learning their perspectives from the front lines of these investigations. I will, just to save them the trouble of repeating this over and over again, the opinions they're going to express are their own. They're not speaking for their offices. They're speaking for themselves. So let me ask you before we get started, how many of you, either the companies that you work for or policyholders of the companies you work for, have been breached? Okay, I should have said, how many of you know you've been breached, since you've all been breached? Okay. One of the consequences that people worry about from a breach is that they will then be rewarded for the breach by being the subject of investigations by the FTC and by state AG's offices like the ones represented here. So one of the things I wanted to start by asking our panelists is, they can't be everywhere at once. They don't have enough resources to investigate every breach. So what are some of the factors that your offices look at that are the most important in deciding which incidents to investigate and which ones not to?
My name is Patrice Malloy, and I'm the Bureau Chief for Multi-State and Privacy for the Attorney General's Office in Florida. And to answer the question, it's the people that we are all talking with, John and Ryan and myself, are very often involved in multi-states that involve privacy cases, mainly breach cases. And the answer is not a one-size-fits-all. There are different factors that go into why does a case escalate and why does it sometimes escalate to the level of becoming a multi-state. A lot has to do, I would say, there are many factors. I'll let John and Ryan weigh in, but I would say transparency. What does the company tell us, when they can tell us what happened? Do they notify us? Is there a background where we can get a good idea of what happened? Does the company know what happened? Are the numbers very, very large? Are we getting a lot of consumer complaints? They're just some of the many factors that go into will we probably escalate. John?
Sure. Yes, John Abel with the Commonwealth of Pennsylvania. I know that Massachusetts is also a Commonwealth, but I'm right here from the home state, and on behalf of Attorney General Kane, I want to welcome you to Pennsylvania and to Philadelphia. The weather is usually better, and so are the Phillies usually in most years. But in any event, like Patrice, I do a lot of multi-states, work with other deputies, Attorney General across the country on a number of matters, just not privacy. And I think that's one thing I would like to leave as a takeaway is, as everyone else in the room is true for everyone in the room and true for us, is, our plates are really full. So, Patrice and I, we might put down the latest breach, and then we're picking up another case that might be a small-time contractor that's ripping off consumers in Pennsylvania, or it might be another large corporation. So we're juggling a whole host of priorities, as everyone else in the room does. So it is a bit of a smell test, I think, as Patrice has alluded to, in terms of, which ones get traction among the attorneys general community. The consensus might grow. We might talk among ourselves and say, hey, listen, this needs a further look to assure that the laws were complied with. I do think that the scope of the breach is very important, and of course the information itself that has supposedly been breached is very important. We all have our own different state laws that trigger those state laws. In Pennsylvania, it's a rather narrowly defined scope of personal information that would trigger our notification statute. So it is, I think, the amount of the scope of the breach, number of consumers, the amount of the kind of information that's been accessed. And I'll be candid with you. If it's a breach within Pennsylvania, within a Pennsylvania company, that's something I'm going to be much more accountable to my superiors and accountable to the public, because it's going to be the Attorney General's office in Pennsylvania that gets the press calls. What are you doing about this breach? This company in Pennsylvania sustained a breach. What's going on with it? How are you protecting the consumers? And I'm going to have answers for the public to my superiors in that instance. So I think the hometown breach is awfully very important for us.
And Ryan, how about you?
Well, I can't agree with you more about locality. A lot of the investigations that I spend a lot of time on are of Vermont companies. Often they're small companies. Certainly the really large national breaches where the number of impacted consumers is into the millions are ones that are going to get our attention. If we're getting complaints about the breach, but we have mandatory reporting in Vermont. We have to be told about the breach directly within 14 days of the breach. I was just looking at our log. We had over 150 notifications of breaches in 2013. I would not be surprised if the actual number was higher. Obviously, there are going to be compliance issues. But one of the first numbers that I look at when I get a notice in is how many days ago did the breach happen? Our statute says that notice has to go out within 45 days. If 90 days have passed, if 120 days have passed, God forbid more than a year has passed, then we're going to inquire more closely. And the assumption is, if you can't be bothered to get notice out quickly, then maybe you also probably weren't able to be bothered to have good security in the first place. That said, I have had situations where notice went out 6 months later. We called, we inquired, and discovered there is actually a good legitimate reason why notice was delayed that long. So just having that kind of delay is not going to necessitate an in-depth investigation. And the last factor that I would just throw out is, we look for cases we can bring that are going to have a deterrence value. We look for really bad fact patterns that we can use to send the message to other businesses that, this is really beyond the fray as far as what you should not be doing. So it's kind of like, you don't have to outrun the bear, you just have to outrun the guy next to you.
Yeah, and I might want to add, there's no magic number. I think it's not like, 10,000 consumers, we got to do this, 20,000 consumers, we got to do that. There's no thresholds that kind of trigger given actions.
Well, let me pick up where Ryan left off, because Ryan talked about the importance of early notification. And as you all can appreciate, one of the tensions that companies have when they get breached is they have obligations to notify the public early or to notify regulators early. They feel a compulsion to notify their consumers, but they don't necessarily know what the hell's happened in the early days. And the forensic investigation can take months. And the last thing a company wants to do is to make a public announcement and then have to correct it and correct it and correct it, because the reputational damage just builds and builds and builds. So how do you assess that? If early notification is important, what should a company do when you want to get notified, but they don't know exactly what they're notifying you about?
And we get that situation. It's not that uncommon. And I'll tell you, maybe answer it first by saying the different ways we see it. First, as Ryan said, we may not hear about it for maybe 8 or 9 months as the company is collecting information. That's not the best way in terms of when we catch up 9 months later. That's a really difficult position for us to be in, because then we're going to have to drill down in what was the reason for delay. Did it take that long for the forensics? Was that a reasonable amount of time? During that delay, were consumers further compromised? Was that a period when their identity theft came about? You've got a gap time that now you've got a responsibility to say, could that have been prevented with early notice? To answer the question of what do you say on an early notice if you don't have all the facts, and I'll go back to transparency, it's better to contact us and say we're in the process of gathering. Here's what we know for sure right now. Here are the steps we're taking to find out exactly what happened. But that to me is a much better position for us to try to assess than being in a situation 9 months later trying to backtrack on what happened.
I'll add that when our statute requires preliminary notice, and basically all that it requires is a general description of what happened, the number of consumers in Vermont affected if known, and the date that the breach happened if known. We've made it clear to businesses that if you get that information wrong, there aren't going to be any consequences from getting it wrong. But in that situation where, and it's happened, where the notice goes out 6 months later, and the business told us about the breach 10 days after the breach, we are much more likely to believe why it took 6 months, because we knew they were on the ball from the beginning. We knew they were trying to comply with the law, but when they have, first violated our 14-day notice requirement, and then they're getting the notice out 6 months later, we're much less likely to be sympathetic. In addition to that, I have had numerous conversations. I just had one yesterday where I got a call from an attorney saying, here's what we know so far. It happened 14 days ago. We're not actually sure whether or not notice should go out in this circumstance. Based on the facts of the case, we're not really sure whether or not this was actually a breach. What do you think? And we've talked it through, and we've talked it through honestly. And I think that when we have that conversation, it's going to, I'm much less likely to do an investigation later on if I know that, we're talking through the issues and things like that. On most cases, our office, if we get called and asked for legal advice, we'll say, well, get your own lawyers. In the data breach area, we are much more likely to talk through the consequences because in that case, we're really we're the lawyers for the public, and we want to make sure that the public gets the appropriate notice, and we're willing to have that conversation. And I think that's in the interest of the lawyers on the other side because it's a complicated area of the law, and we all recognize that.
So is it your recommendation then, your personal recommendation, not on behalf of your offices, that if a company is still trying to figure out the number of consumers affected and still trying to get its arms around what happened, but is investigating to find out if something happened, that they make a preliminary notification to your office, even if they're not ready to tell the public or their customers yet?
Well, that's a complicated question as far as telling us and then not telling the public, because then we're in a position where we know. And that's a difficult, if it's a position where you know that it's going to be identity theft, it's their social security number, it's fact dependent, that would be difficult for us to say. We could understand why it's not out there. Sometimes there's substitute notice where you may not have the names, you may not have the number, but if you shopped here, if you bought X there, that you can get it into the media, some type of press release that if you were in any possible that you were exposed to this, be aware, start watching your credit. So there are ways to do it, but to answer yes, I think the advice would be contact us. We can't be in a position where we're giving legal advice, but as Ryan said, we can certainly walk you through what we can do and what other companies have done and that has worked for them.
And in the event, there sometimes does happen where we get the preliminary notice and they decide later on down the line that it did not fall within the definition of our security breach. Mm-hmm. Or we have an exception in Vermont where if you have a security breach but it's not reasonably likely that the data would have been misused and you still have to notify of that and they decide it falls within that exception. I've gotten calls from the other side where they've called and said, hey, we had a breach and we're about to send out notice tomorrow, and they talk me through the facts and I say, I got to tell you guys, you didn't have a breach. You're actually overreacting in this circumstance, and I don't think that there was a harm, and I've actually talked businesses out of doing notice, if you can believe that. So, I think having that conversation, and also in Vermont statutorily, that communication is confidential. We don't do a press release. We don't talk about it. It's a one-on-one communication.
Well, and I think Ryan has a good point. You really have to check each state law in terms of where your notifications are triggered. In Pennsylvania, the notification has to go to the public. It's not required to give it to the Attorney General, although I think that's probably a sound business practice to give notice to this office again, so we're not kind of playing catch-up. And I think Patricia's point is a good one. I understand we're all law enforcement. I wouldn't even call ourselves a regulator. I think we're more like a law enforcement. So our job is to make sure that the consumer protection laws of a civil nature are being complied with in every respect. So our obligation is always going to be first to the public in terms of what we have to let the public know. And the anecdotally, I can tell you, I've been doing this for probably 10 years, if not longer than that. And rarely have I seen the news get better in the cases I've been involved with. So the idea that let's wait, let's run a few more tests, let's see if if the facts come out more in our favor. My experience has been the longer you wait, the worse it gets. So I think we all fully appreciate the tension that's there because you don't want to jump the gun and harm the reputation of your firms. But of course, my orientation is to err on the side of notice, to get in contact with us. We're very easily accessible. As Ryan said, we're willing to listen. And to some extent, then if you're proactive like that, you sort of control the story rather than being reactive when we're saying to you, what happened here? When did you hire the forensic expert? When did you learn this? So to some extent, you're able to control the narrative, I would think, if you're out front engaging in a dialogue with the State Attorney General office.
Now, what if I'm in the early days of my breach and I'm still trying to figure out what the scope is? I don't quite know yet, but I want to have some early engagement with an Attorney General's office so that I'm getting credit for attempting to be proactive. But I don't know what states consumers are affected. I don't know if it's confined to one state or 50 of them. How should companies deal with that? Is there, should they go to the place where they have the greatest amount of business, the place where they're headquartered? How can they get information to all of you without having to make 50 phone calls?
That's a lot of times. I think practically they do have to make a lot of different phone calls, unless they know of a multi-state that's been formed, which is unlikely because they're just giving the information. So I think short of probably, and what we normally have is the usual people in each state who do privacy get the phone call, and it is several calls. I don't know of a more practical way.
Yeah.
I would say that if it's a small regional breach, if you really don't know, how many states were impacted, at the very least call your own state attorney general. Mm-hmm. If you don't even call if you have customers in state, if you don't even call your own attorney general, it's going to be hard to argue later on, well, we didn't know who was impacted. If it's the big national breach, yeah, you may be doing a lot of phone calls, but you can also get on the phone with some of the AGs and say, is there a way to arrange to talk to everyone at once? And sometimes that can be arranged depending on the scope of the breach.
And it's interesting on a practical level. I will get calls from someone saying, it may be X amount in Illinois, it's only 8 people in Florida, but I just want to make sure you're included. So we do get those calls, even though obviously that's not something that we would be following up on unless there's a fact pattern there that warrants it, but unlikely.
Now, how often do your offices get together on the phone or otherwise through email to share information about investigations?
I'd say regularly. I mean, it's regularly and ongoing. It's a number of states, and I think there's some states that are more involved than others. But I mean, this is a dynamic process, and by no means is it sort of like once in a blue moon we're talking about this. We're in communication quite regularly about this. It's a rather robust dialogue, I would say.
And one of the reasons for it is, frankly, is the volume. In the past year, things have escalated. They were escalating, and now they're to the point we work together. It's much more efficient to have a lot of states looking at a single issue that may involve huge discovery. It may involve facts that different people are good at getting. You may need forensics, may need an expert. So it is very frequent. We work together constantly, especially the people in the privacy groups.
So we've talked.
You can assume that if there's a major breach that has happened, that we are talking about it.
Yeah. And the other important thing to notice is, I mean, there's a, I don't know how you put it, but a esprit de corps among deputy attorneys general in that we do like to work together. We like to create synergy and play off our respective strengths. At the same time, there's no overarching like boss of all the states, if you can understand that. So each state at any point in time is free to kind of go off on their own and bring a lawsuit or ratchet up the investigation or pull out of an investigation. We all our own state. We're our own sovereign. So a multi-state process is interesting in that regard because we work together and oftentimes to our own interests in a cohesive manner. But because we're all our own states, any state at any point in time could say, "Listen, I'm going off and doing my thing," and they're entitled to do that. They're entitled to do that.
It's like working for a giant law firm that has a branch in every state, but at any given moment you can tell everybody else to just go pound sand.
Yeah, right.
But we never say it that way.
We don't say it that way.
Close.
We don't say that in my firm either. So we've talked about a number of factors that go into your decision about, or that factor into the decision about whether an incident should be investigated. You mentioned the size of the breach, the number of victims, nature of the information compromised, the location of the breach, timely notification. What about cooperation and engagement with law enforcement? Is that when a company is working cooperatively with the FBI, with state or federal law enforcement, and sharing information with law enforcement to investigate the breach, is that a factor that goes into the overall calculus in your assessment of that company?
It's certainly a factor in that if the FBI or an agency would request that something not be public and we're not a part of it, we certainly wouldn't want to interfere with that investigation. As John said, we're civil, we're not criminal, and as we know from past breaches, there's often the criminal side and then there's the civil side, which we're consumer protection. So just from a general philosophy, we don't want to interrupt anything like that. So if it's verified that there has been a request to not be involved, we'll look at that very seriously. We don't want to get in the middle of that.
I wouldn't go so far that you get brownie points for cooperating in the investigation, but I can tell you, that's going to work into the analysis in terms of what's an appropriate resolution. Obviously, what we want to do is get to the facts. As quickly as possible, learn the facts. I know sometimes that's complicated and that's difficult, but and we'll go wherever the evidence leads us. If the evidence leads us to there's no violation, then we're moving on because we've got plenty of other work to do on our plate. So we're essentially trying to get to the facts of the breach and what predated the breach and what postdated the breach. So that's as a law enforcement body, when we conduct these investigations, it's no big secret that's what we're driving at. I think to the extent that the company can cooperate and say, listen, hey, Madam Attorney General or Mr. Attorney General, this is what I know right now. This is what I don't know. And I'll try to find that out for you. And this is what I'm told right now, and I don't know the answer to that question, but let me try to find it. I will tell you, one bit of advice, because a couple of things I want to make sure I said today before the time gets wrapped up, is, it's not good if we hear publicly about the scope of the breach before we're told by the company. So to the extent that there's going to be the company's going to go public and say, well, listen, we've learned more about this breach today, that it was not 20,000, it was 200,000. It's probably a good idea to let us know that first before we read about it in the paper. It's sort of like, keep us in the pipeline. Understand, if you want to inform the public, that's great. We'll applaud that. But we would like to be kind of in the know as you gain more information that expands upon what you told us before, or you need to alter or change what you learned before. Say, listen, we told you this, we learned now that number is incorrect. Here's the more correct number.
And to answer your question, yes, cooperation with law enforcement, we absolutely encourage it, and it is recognized. But I would say that the other thing is we also recognize when we aren't told, and John has brought up a really good point, because what happens is it's in the newspaper. Then our offices are contacted. Our consumers are calling. What are you doing about it? Do you know about it? Then we're in a position we don't know about it. We haven't contacted the company. We haven't taken any steps to give consumers any kind of advice. So it really puts us in a very difficult position. And the press coverage in this area, I think, has become more prominent over the past year. So that is happening with us.
And if I could put an even finer point on it, I'd say 95% of the breaches that I get notification on, I don't hit the press. They're not that big a breach. But every once in a while, I will hear about a breach from law enforcement or from a financial institution that happened in the past and no notice went out. And I have started shifting my focus slightly away from the guys who give notice but maybe do it poorly or maybe do it late, to the guys who did not do notice at all, of which there are a number of them, and I am bringing very strict methods to bear on those companies, because that's just a complete violation of the Act. If I contact them before notice has gone out, and I'm talking 60 days out, 90 days out, my assumption is they weren't going to do notice. And then that's a real violation, and that's something I take very seriously.
So I'm going to start with Ryan and see if you all want to weigh in too. Ryan, one of the things that we've talked about before is the importance of early response when the company gets wind that there has been an incident. And I know one of the things that you focus some of your cases on is situations where there is a breach or there are indicators of a breach, but the company is slow to actually investigate it itself, putting aside the question of notice to the public or to your office. Talk about that, the importance in your calculus of the company's response rapidly to the early signs that there has been a compromise.
Oh, sure. And we have to explain there that when we're talking about that, we're getting out of the Consumer Breach Notice Act into the Consumer Protection Act, which just generally prohibits unfair and deceptive acts and practices. In Vermont, it's $10,000 per violation. This is the theory that the Federal Trade Commission recently had a victory in the Wyndham case. So that's the theory we're talking about. We had a case here in Vermont where a small business, was notified that they might have a breach. Financial institutions had traced credit card fraud to their business. The business did not take any steps to even find out what had happened. And this was a small business, but the first reasonable step even for a small business would be, pull the hard drives from your computers and check your POS systems, make sure there are no skimmers. I mean, there's low-cost stuff you can do, and they let that go for months. There were people in the state of Vermont who were having their credit cards stolen at this business, getting new ones issued, within days taking those credit cards back to the business, having their credit cards stolen again. We had one consumer who had their credit card stolen 3 times at the same business because the business had not taken any steps to fix a breach that they were on notice of. That's really the worst case scenario. And it was a small business. We ended up entering into a settlement with them for $30,000. And we allowed them actually to use a portion of that money and put it towards upgrading their systems instead of paying the state. So it ended up paying the state about $15,000. But that was also a very small business. I want to contrast that with another business that I heard from in Vermont. It was a chain of bagel bakeries. I got a call on a Monday. They said, yeah, we became aware of a breach last Thursday. We contacted the Secret Service on Friday. I'm the president of the company. We pulled all of the hard drives. I'm calling you now. What else do I need to do? And my response was, you're doing great. Call me in a few months and tell me how it went. I'm not worried about you at all. I mean, that's the best case scenario in a situation like that. So that's kind of the spectrum.
I would reiterate. I mean, it seems like you can't. You can't do the ostrich. You got to get your handle on it right away. Roll your sleeves up and gain as much information. If you have to bring an outside firm in, do that. Run the audit. Stop the bleeding. I mean, if there's been a vulnerability exploited, plug the vulnerability or take whatever steps are to prevent further breaches. So it really requires immediate action right away. And if you have to bring somebody in from the outside, do that. But get a handle on it as quickly as possible, as I said, because the news, in my experience, rarely gets better. It gets worse as time goes along if you're not really stepping up and affirmatively, kind of proactively handling the situation.
So one of the things that has come out of the Target breach, I think, is a increased degree of attention and focus in the public's mind and the government's mind and in companies' minds on the fact that it's not enough anymore to be worried about their own cybersecurity. You have to worry about the cybersecurity of your vendors, business partners, in Target's case, your HVAC contractor, anyone who's got access to your network, and that could even be your clients, depending on the client. It's really 2 questions from that. First, are you seeing more breaches that are coming to your attention that are the result of access to a third-party system, not to the ultimate target of the breach, but they access the target system through a third party? And does that factor into the calculus about your overall view of the culpability of the company, that their network wasn't directly compromised, but there was an access, but a vendor was used as a launching pad?
I say briefly, yes, we're hearing more about that. I think because the awareness has been increased, that maybe before we didn't hear about that breach, but now people are realizing there's an exposure there, a possible exposure. We may have cases where the third party says that the target or someone may they should not be issuing the breach because they were just a third-party vendor. So I think it's getting very interesting in that area about who will send notice, who is responsible, who ultimately, for us, we can't get into the middle of that fact pattern because, as John always says, time's of the essence here. So we're not sure in the beginning who should send it, but we want somebody to send the notice out, and the legalities you guys will have to figure out.
And you're right, and I don't know which way the identification runs in those contracts. I'm sure there's identification one way or the other. But the last thing that I want to hear is I go to the company and they're pointing to the vendor, and the vendor's pointing back at the company. So like, well, it's not me, it's this guy. Well, no, it's that guy. And as Patrice says, well, listen, you work that out yourself, but again, we got to protect the public and make sure the law is being fulfilled. I think it does seem like the vendor's coming up more often. Mm-hmm. It does, compared to a year or two ago. It's I can think of a couple cases now that have popped up on our radar screen. Whereas the vendor was allegedly the one that sustained the breach.
I know that I was just going to say, I do hear that people are looking at those contracts on indemnification more closely to see exactly what happens in the event of a breach. So that awareness has definitely been increased. Ryan?
Yeah, I'd add absolutely. When the finger pointing happens, that is very frustrating from our perspective. One of the pieces of advice we've been giving, especially small businesses, for over a year is don't try to process the credit card, using your homemade system. Outsource it. It might cost you a little bit more, but let a vendor handle your processing because they're experts at it. So when we do find out that the vendor got hacked and the vendor is pointing the finger back at the small business that was outsourcing that to them, that actually makes me kind of frustrated. Because in that case, often the small business who may want to be the one who does the notice because they're the one with the relationship to the customer, and that's why they really have to work it out. But when the vendor who actually got hacked is trying to wash their hands of everything and saying, not our problem, that can be a real frustrating problem from our perspective. And the only other thing I'd mention in terms of third-party issues, which probably most of the people in the audience are aware of, is if you have people using remote desktop software, especially if it's remote desktop software trying to get into POS systems, that stuff can be implemented safely, but you have to do it very, very carefully, and there's a lot of breaches that occur because of that. I think the latest Verizon report actually pinpointed that as an issue. So that's an area where we also see a lot of third-party issues showing up.
So that's actually a good segue to a related topic. One of the complaints I used to hear when I was at DOJ, and I hear it a lot more from companies that are now my clients, is that they feel that that we're in this sort of blame the victim cycle. When a company gets breached, it's not just the consumers that are victims of the breach; the company's a victim as well, and they fulfill their notice obligations, and they tell the public and they tell the government, and maybe they even engage with the FBI or Secret Service. And they feel like the reward for that, or what follows from that, is investigations by regulators, by the FTC, by HHS if it's in their jurisdiction, by state AG's offices, and then there's this race to the courthouse by class action lawyers who have Mad Lib-like complaints up on their screens, waiting to fill in the name of the breach victim and the date, and then run to the courthouse to get filed the same day the breach is announced. And then you've got members of Congress who almost immediately after a breach is announced make public statements that suggest that there's a presumption that the company is negligent until proven reasonable. It's like being guilty until proven innocent. But at the same time, these companies complain, and it's not just Wyndham and LabMD, although they're the most dramatic examples, that there is no standard about what is reasonable. Ryan just rattled off a number of things that are eminently sensible, but there is no regulation, at least federally, that tells people what reasonable cybersecurity is. So you've got this situation where companies, a lot of them feel like they're sort of fishing in the dark, and if they're doing the best they can, and if they fail, perhaps because of the actions of a really skilled hacker, the public blames them. So with that that's the environment in which we all operate in. So how do you respond to that, and how do you factor that concern in the work that you do?
Well, there's so many different, I think, issues in there. I think the first one is the victimization, and I think I heard that more maybe during the TJX case when people were debating, this happened, but the person who went in there, he did X, and who's the victim? And what has evolved is that consumers want to be protected, and the issue of if it was a highly sophisticated hack or was it, as we've heard today, sometimes maybe it wasn't so sophisticated. It may have been something that could have been very easily prevented. The keys were in the ignition. So we're constantly in that balancing act of saying, were the protections there? Were they reasonable? What happened during this breach? And that's why the investigation stage is pretty complex. So I guess it's defining, were they truly victims in the sense that they took all the precautions?
Yeah, and I'd add 2 points there. First, I get how if a business is being focused on by the government, they can feel like a victim. Based on the numbers of reports that I'm seeing coming through Vermont, the number of businesses that we actually look at is probably less than 5% of the breaches, and it may be closer to 2 or 3% of the breaches, and those tend to be the most egregious breaches. So I don't think, and I think very likely those are the folks, Jason, that are hiring your law firm. So you're hearing from them because they have some pretty bad breaches going on. So I don't really think that this blame the victim is a widespread problem. I think it's the ones who really had the more egregious breaches and are being investigated tend to be the loudest. That's my personal view. My personal view on that. And in terms of what does reasonable mean, I don't think setting down a set of here's exactly what you have to do is the answer, because that set of standards is going to be out of date pretty quickly, or it's going to be so broad and vague that it's going to be almost impossible to interpret in a helpful way for businesses. What it comes down to is, if we see a breach, we talk to our forensics guys and we talk to experts in the industry and we say, hey, for a business of this size, in this industry, do you think that they were within the margin of reasonableness? And we look for the ones where the experts say, wow, that was a really boneheaded thing that they did. That I can't fathom any IT person, who should not be fired doing that. Those are the cases we look for. We look for the really bad ones because, we don't want to be arguing in a court, they should have been using 256-bit encryption versus 128 or something like that. We're looking for the low-hanging fruit. That's what we have the resources and the drive to go after.
Yeah, that's a good point, Ryan. I mean, I think if you think if it's the bullseye, we're looking for the outliers. I'm not going to spend my time on a case that's a close call, whether or not it was reasonable or not. We don't have the time to do that. To kind of spend time on a case, and obviously our obligation as officers of the court and as representative of our respective offices, the part of the analysis of us always has to be, if we're going to do a settlement, we should be assured that there's a good faith basis and fact in the law to take that to a fact finder and convince that judge or that jury that the law was violated. So, that's the premise. It's like, what do we have? What's the law? What can I prove? What can I not prove? And if it's like, that's not going to the case we're going to put our resources in. So I think Ryan hit the nail on the head when he says, we're looking for the outliers, the ones that are beyond the pale in terms of what could be reasonable and expected of the company. And it's not that we're unsympathetic. Certainly, if you have a bad guy out there, a hacker that's intent on breaking down the security, we're well aware that that's out there. I know part of my response to that is we understand that, but at the same time, the companies are gathering up highly personal and private information of consumers. That's the business model. That's what the company uses. So if the company is going to then take that information and use that information to its own advantage, then it has a responsibility to the consumers to ensure that it's adequately protected. So it's sort of that's built into the business model. And we certainly have seen a sea change now in the past couple of years to understanding the importance of protecting the privacy of that consumer's information. That really has to be part of the entire operations of the business. And particularly when there's, and I don't want to go into theory much, but one of the theories we go into is if you're a company and you have a privacy policy and you're representing to Joe and Jane consumer that come shop with me, come to my internet site, come here and you can shop with confidence because I have this privacy policy and I'm promising or I'm representing to you that we will do everything possible to safeguard your personal private information. And if in fact we find out that that didn't happen, then that is a misrepresentation. I mean, that's our thought analysis, okay? That is a misrepresentation. That's a deception because you're saying, here, come to us, we're going to protect it, when in fact you weren't. That misled consumers then, in our view.
And just adding to that, it's funny if you think about it. 15 years ago, I think as early as that, there was no idea of e-commerce. Remember, when the internet was starting, people had to convince consumers to put their credit cards on a website because consumers naturally realized that this might not be a safe thing to do. And over time, businesses have managed to make that argument, and they've won that, so consumers feel safe putting their credit card information out there. But it's starting to look like maybe we spoke a little too soon. So I think businesses and our offices are in the same position that we really want to keep consumers convinced that it is safe to put their credit card information out there in order to keep this, this engine of our economy going. So that's just something that it's really everyone's responsibility to help make sure that they're keeping their security as high as possible.
But, you mentioned 15 years ago, and I think that's the challenge that we're all facing for different reasons of what was expected then. And even this morning when we heard that maybe the number of laptop breaches is down, and I thought, well, that's really good. But then I started to think, but the last time I went to a meeting when I saw a lot of laptops, I guess has been about a year. People are on their iPads or they're doing something different. So, the challenges of keeping up with the technology, of consumers becoming more educated, of lawyers who are in this area learning more about it, and also who we're speaking with today. It's such an escalating area that I think you hear from us that we're in that process as well.
Yeah. I know everybody heard NPR this morning, but there was a spokesperson for a large company that said, well, now you have the gold standard for privacy protection, and said, well, the gold standard today will be obsolete tomorrow, and that's how fast the technology is moving.
So we're gonna move on to asking our panelists to use some real world examples from cases that they've investigated or considered investigating, and to give you some sort of takeaways from those cases about what the companies that did it right did well, and what the companies that didn't do as well or really struggled with incident response need to improve on. But before we do, we've thrown a lot out at you about some of the factors that these offices and their sister offices or partner offices consider when they decide what to investigate. I was just curious, how many of you in the breaches that you've experienced, at least the ones who know that they've been breached yet, how many of you have struggled with these notification issues we've been talking about? When to notify, this potential tension between getting it right and getting the information out early. I don't know if anyone wants to come to the microphone or if you're all just planning your first drink in 10 minutes, but if anyone's got their own sort of good or bad story to share with, you don't have to name the company that was breached. All right, I figured I'd take a shot at that. Ma'am.
I'll just say it was our breach attorneys who were there that helped us, because when it came to the leadership staff, especially the head of IT, who I think felt a personal issue with it, he was trying to really instigate the CEO and kept throwing dates at him and was actually kind of going crazy. But and we talked earlier today about having a person in charge. He was never the charge person. But I think the attorneys just kept us focused and just said, this is what we're doing. There's plenty of time. This is what we have to do. But you've got to be, I think that's why it's got to be so tight-knit of who is, if you can do that, of who knows what's going on, because people, even in leadership positions, sometimes have their own interpretations and are not attorneys and want to make up their own minds about doing things.
You raise a terrific point. One of the things that when we advise clients about preparing for an incident before it occurs and responding to one when it occurs is somebody's got to be in charge. And you've got to have a plan, and you have to have not just written the plan, but actually tested it through tabletop exercises or breach simulations before the incident occurs. Because a breach is a crisis, and you never know how your people are going to respond in a crisis until it happens. And so if you can test the plan, and you've got the lawyers there, the tech people there, the corporate communications people, you're much better prepared when an incident occurs, because it's going to occur, at responding effectively and conveying to folks like these that the company is on top of it. So let me ask you guys, in your overall impressions of a company, when a company's dealing with an incident, how important is it that you get the sense that somebody's in charge, that the company is really on top of the incident?
I think that is such a key area. I'm really glad you brought that up. I think it's a management and monitoring issue that we hear. And the management starts with being proactive prior to the breach to know what's their data at rest. Are they encrypted? Do they keep up with software changes and updates? All of that is a management issue before and monitoring. Then at the time of the breach, it's obvious if someone isn't in charge, because I think that's when you get so many different answers. And someone eventually has to emerge as the leader, and it may be the breach attorneys, because they end up with outside counsel, or if they're handling it inside, someone takes it over. But that point person wasn't designated prior to the breach, and that's a tough follow-up for someone in the midst of a crisis. They're trying to produce a product, but what has become apparent is they're consumed by the incident of the breach itself.
Yeah. I mean,
Sorry, go on, Joe.
What we want to hear, again, is sort of what, we want to hear from one person. I think that helps. Like a spokesperson who's in charge, putting a person, the point person. And, of course, obviously, one of the things we're going to want to find out is what has the company done before the breach? And we were talking about this a little before. I mean, to what extent were you doing audits? Were you updating? Were you updating your privacy policies? Were you having, were you doing your due diligence? And if you had a vulnerability, to what extent were you addressing that vulnerability? So, we're going to look back in time to the breach to see what was going on. It's for us, it's good to have one person come and say, listen, all right, well, let me tell you, John, here's what we've been doing. We put this team together back in X year, and we do these audits, and we found this audit, and we took that step, and then we found another vulnerability, and we addressed that step. So give us an account of what was done beforehand to demonstrate reasonable, to demonstrate due diligence, and get that to us.
I'm going to add, and this might be a little unpopular, but we're repeat players in these actions, and when we find ourselves dealing with outside counsel, I have noticed that outside counsel falls into kind of two buckets. One is the group that their job is to contact attorney general's offices. And if it's an antitrust violation, if it's a pharmaceutical issue, if it's a tort, it's the same guy, because their job is to talk to attorney general's offices. And then the other bucket of outside counsel we'll deal with in data breach are people who deal with data breaches. And they deal with a lot of these data breaches. They've got experience. And we get experience with them too, because we hear from them, we talk to them, we develop relationships, and we develop a sense of trust. If I'm hearing from an outside counsel, and then there's inside counsel, which is fine too, but if I'm hearing from outside counsel on a data breach, I much prefer to be talking to the latter, the guy who understands data breaches and is going to be able to give me the information that I want and that I'm going to trust, has understanding of this, rather than the guy whose specialty is talking to me or, theoretically talking to my boss if I say something he doesn't like.
And Ryan has a good point, because eventually, if it keeps going in terms of our looking at this, the IT people, the forensic people do end up talking. It's a lawyer issue, but it also, to figure out what happened, it ends up there. So you have a good point.
Yeah, and I want to make this point because somebody mentioned. I think it's also important, and then maybe it's obvious, but we're completely distinct from the class action bar. So I mean, whatever that class action bar, whatever those plaintiffs' lawyers are doing, that's their thing. And we're really, again, we're not looking for pecuniary gain. What we're looking is to make sure, and I think we're all in the same room, we're all on the same page in this room, that we're trying to protect consumers and protect consumers' information. I mean, there's no question about that. So that's our angle. I think sometimes we get clumped in with the class action bar, but we really have a different agenda than those folks that are bringing private lawsuits.
Yeah, I have to say, when I talk to companies about who's in charge, when we're helping them take the relatively inexpensive measures you can take before an incident occurs to put yourself in better stead with state AGs and regulators and others after a breach occurs, you get one of two responses. You ask who's in charge, and either four people raise their hand or everybody starts looking at each other. And they're both the wrong answer. You need one person who's in charge, and you need the whole team there, but you need one person to be the point person. So I'm glad you guys emphasize that as well. What I'd like to do then is, because we don't have a lot of time left, is ask you for a takeaway or two based on cases you've investigated where a company really did something well that should be emulated, or a company did something not as well that should be avoided.
I think just, we may circle back to notice. I think when I see somebody do something well is they let us know early. They have as much information as they can give us. They schedule a call. They are very transparent. They're upfront that they may not have all the information, but here they are. They're going to send a notice letter, would I like to see it? So if our consumers call us, they'll know it's legitimate, that it's not some other problem they're going to have with a hacker. So I think those kind of cases, and I've had several companies who have done that, it's worked out well.
John?
Yeah, I would reiterate that. I mean, I think the message has to be proactive, get the facts straight, get in touch with us, establish a line of communication early, and make it often. I mean, we're going to be available by email, by phone call. So open up that line of communication as quickly as possible. And again, I think it's get to the facts. I mean, I think there's a time and place for the lawyering on these issues in terms of to what extent does it fit into the unfairness criteria. To what extent does it constitute deceptive? But we're pretty firm in our positions over here on this side of the table in terms of what the law provides. So I guess what I'm trying to say is let's get to the facts and let's leave the lawyering in terms of the arguments. That's really a different discussion, and I don't think it really moves the ball forward certainly in the early stages of an investigation.
Ryan, how about you?
Yeah, adding to that, to get to the facts, and when we do hear the facts, we generally appreciate if the company is a good corporate citizen, how many employees they employ, if they've been giving to charity. We don't generally need a complete description of every security method they have ever implemented to show what a good citizen they are. We want to know what happened. We want to know what went wrong. And because we are often making these split, these quick decisions, if it seems like the lawyers are withholding something, if we're saying, oh, can we see the forensics report? And they're saying, no, sorry, we can't show that to you. If we start hearing things like that, it triggers they're hiding something. And sometimes that makes us say, oh, I think we need to look deeper. And often if we just get we get the full picture out there, maybe we'll see something didn't go as well as it possibly could have, but it wasn't that big a deal. And it's, because it's not that outlier. So fine, we'll move on.
Yeah, I think it helps to understand that you have a job to do, and we have a job to do, and our job again is to see the laws are complied with. So I always go by the old Ronald Reagan, trust but verify. That's fine. Okay, well now show me, give me the documentation to prove what your lawyer's asserting is what happened.
So we have very little time left for questions, and every question is a delay in your drinking. But with that, anybody brave enough to take the mic and ask a question? Next time you should put me at the beginning. No.
I would add one thing about forensics, unless we get a question, and that'll trump it. Yes, yeah. Question. Thanks. Go ahead.
Is it my turn?
Yeah.
Not a lawyer, InfoSec guy, but I follow all this pretty closely. Is there a requirement to continually update the state AGs beyond your initial notification? You've spent a lot of time talking about keep us in the loop. And I'm sure it varies state by state, but I guess when I've read breach notification regulations, it seems like, you need to tell them once. It doesn't really say a lot about keep them in the loop.
Well, that's a good question. Just one brief answer is, do the facts keep changing? Many times we are kept in the loop because it's X amount 1 month and 3 months later the number has increased, or the content, the nature of the data has changed. So we do ask that we are kept in the loop, so there are no more surprises, since we've already known that they've given a notice letter and things like that. John, any follow-up on that?
Well, no. I mean, I think obviously there's a law that's going to control, so I think the keeping in the loop is probably just good advice. But, if the law gets triggered, you got to give notice, but you don't have to keep giving notice. You know what I mean? Once you hit the threshold on our law, then the notice has to go out. There's not a continuous notice requirement in our law.
And I'll just say, Vermont technically requires 2 notices, that 14-day preliminary notice, and then when the notice goes out to consumer, we get a copy of that. So if notice goes out to consumer within 14 days, you just collapse them into one and you're done. If you send us one at 14 days and one at 45 days, you're done. The only in the loop would be if you start approaching 50 days, 60 days, 70 days. After telling us at 14, you may want to call us and explain why it's taking so long.
I have a question over here about the form of notice to consumers. I've seen some reports that email notification can lead to spoofed emails and more issues with fraud. Are you having any concerns with that, or any dialogue with companies about how they're giving notice when they have choices, if they have the information to do it either way?
Are you asking how do we verify it for consumers, or make sure that they're not subject to some type of phishing that's not really your company?
Right.
Yeah, I mean, we have had press releases that have advised that. We've also at times had the notice letter on the website. We don't do that as a general rule, but if there's a situation where the notice from the company is on the website where the consumer can verify, that's not that common, but there are many different things like that. Any other ideas that you guys?
Well, no, I think every time there's a big breach, that's the second thing we always think about, because every time there's any kind of story, there's going to be some bad guy out there who's going to try to exploit it and try to start phishing and start calling consumers to get their account information. So that's probably the next thing. That's probably in the first press release. Consumers should be aware, not to fall vulnerable to a phishing scam.
So we actually in our statute state that if you are going to do email notice, you can do that if that's the way you normally communicate with your customers. And we also state that there cannot be a link in that email that leads to asking for any sort of personal information for exactly that reason. So if you are going to do email notice, just make sure it complies with the law and couldn't potentially be a spoofing email.
And one of the toughest thing I find is consumers say, okay, they are offering credit monitoring. Now I have to put my personal identifying information on a website. I'm really uncomfortable. Now I'm even more uncomfortable. So.
That's a good point.
I think there's another question. Is there another question? Any other questions? Rick Bortnick, you're out there. Oh, he always has a question. Do you have a question? That's right, exactly.
Who's buying the first round?
Yeah, right.
He didn't really, that was his question, Jane. No, that's the way it is.
I got Ryan's credit card number,
Thank
so
you.
we're good for the first round.
Any other questions?
It's from Vermont. It'll buy a PBR.
What's your favorite beer up there, Ryan? Magic Hat?
I prefer Switchback Ale. That's my
Switchback?
Switchback.
Okay, nice job, panel. Thank you, guys. Thank you, Ryan.
Thank you.
Patrice.